There is a number your mother has probably never heard, and on the day she applies for Medicaid, it is the only number that matters. $2,000. That is what she is allowed to have left, not $2,000 a month. $2,000 total in countable savings before the state will pay a cent toward a nursing home that runs about $9,600 a month. So most families do the obvious thing. They spend it. They watch 40 years of saving drain out at $9,600 a month until the account is nearly empty, and then they apply. Here is what nobody at the facility tells you. The limit is not a limit on what she can own. It is a limit on what the state can see. And there are things she can own that it does not count at all. 3 of them in this video, and they get bigger as we go. The first one she can set up this week without a lawyer, and it carries no penalty. The second can move a 6-figure retirement account off the books with 1 phone call in about a dozen states. The third has no ceiling on it at all, and it is also the one that can backfire. So I have put it last, and I will tell you exactly why. Subscribe. This is the part nobody explains. 2 women, same street, same year, both 79, both with a husband still at home. Joan and her husband had $200,000. Wanda and Ted had $200,000. Joan sat in a savings account, which is the sensible place for it to sit. 20 months later, Joan had spent all but $2,000 of it on care, and Wanda had spent almost none. Same money, same state, same illness. What separated them was the form the money was in on the morning the application was filed. So let's be precise about what countable actually means, because the word is doing more work than it looks. When your mother applies, a caseworker sorts everything she owns into 2 piles, countable and not countable. The countable pile has to come down to $2,000, and the not countable pile is already bigger than most families realize. Her home is not counted, up to $752,000 of equity in most states, while she is alive and either intends to return to it or has a spouse living in it. 1 car is not counted, whatever it is worth. Her furniture, her clothes, her wedding ring, none of it is counted. So the house and the car are already invisible. It is the savings that are not. Now, some states are more generous than the federal floor. California reinstated its asset limit on the 1st of January this year at $130,000. New York sits at about $33,000. Illinois, $17,500. Most of the country is at $2,000, and this is the part that decides everything. The caseworker is not asking how much money she has. The caseworker is asking what form it is in on that day. Cash is countable, a car is not. Both are value, only one of them counts. Sit with what the ordinary path actually costs. $200,000 at $9,600 a month is 20 months. 20 months of writing a check to a facility for the full amount, while the state waits for the balance to hit $2,000. At the end of it, she qualifies, and she has nothing. That is the system working exactly the way it was designed to work, and almost every family walks straight into it, because nobody ever told them there was a second door standing right beside the first one. Which turns the whole question around. Instead of asking how fast her savings have to disappear, ask which of them can be moved into a form the state does not count. Legally, on the record, in the open, 3 ways they can. Number 1, and this is the small, fast one, an irrevocable funeral trust. Your mother is going to have a funeral. That money is going to be spent. The only open question is whether it sits in her bank account being counted against her while she waits, or whether it sits somewhere the state cannot see. An irrevocable funeral trust takes cash out of the countable pile and puts it toward the funeral, permanently. And here is the part that makes it unusual. It does not trigger the 5-year look back. There is no penalty for setting one up. She could do it the week before she applies. Almost nothing else in Medicaid planning works that way, and it is the reason this one is first. How much depends entirely on where she lives. It runs from about $1,500 in Alaska to over $30,000 in parts of Pennsylvania, and roughly half the states set no cap at all. And in Michigan and New York, this particular tool is not available. So do not take a number from a video. Take the range and ask about yours. She has to be the one who signs it, so your job is to make sure the right words get said in the room. Go with her or write them down for her. She is asking the funeral home for an irrevocable funeral trust, not a prepaid plan, not a pre-need contract she can cancel. If she can get the money back, the state can see it, and it counts. Then she asks for the itemized goods and services statement in writing, because about 20 states require it. One more thing to know going in, and it is fair that you know it. Most states require the state to be named as the residual beneficiary. Anything left over after the funeral goes back to the state. This protects her care, not her estate. That one moves a few $1,000s, and she can do it herself. The next one can move 10 times as much, and it is still just a phone call. Number 2, the retirement account and payout status. If your mother has an IRA or a 401k sitting there untouched, in most states it is a countable asset, and the whole balance counts against that $2,000 limit. But in about a dozen states, the moment that account is in payout status, taking required minimum distributions, it stops being counted as an asset at all. The monthly payment counts as income instead, and income and assets are two different tests. Think about what that does to the arithmetic. A $180,000 account, counted as an asset, is $180,000 she has to spend before the state pays anything. That is nearly 19 months of care at $9,600 a month. In payout status, in a state that allows it, that same account might send her, say, $900 a month. And it is the $900 that is looked at, not the $180,000. The balance comes off the asset side with one phone call. She rings the plan administrator and asks to begin required minimum distributions. Now, I want to be careful here because this is the most state-dependent thing in this video. About a dozen states do this for the applicant. Most states do not, and count the account either way. There is a separate group of states where a spouse still at home keeps their retirement account regardless. Nobody should act on this from a video. Ask an elder law attorney in your mother's state whether yours is one of them, and ask it before anything is moved. Those are the two she can start this week. The third is the largest, and it is the one that needs a professional in the room. Number 3, a Medicaid-compliant annuity. This is the one with no ceiling on it. It converts a lump sum of countable cash into a stream of income, and if it is built correctly, the lump sum stops being an asset the day it converts. Federal law spells out exactly what correctly means, and there are 4 conditions. It has to be irrevocable, it has to be non-assignable, it has to be actuarially sound, meaning it pays out within her life expectancy and not a day longer. And it has to pay in equal amounts, with no deferral and no balloon payment at the end. On top of those 4, the state has to be named as the remainder beneficiary. Miss one of the 5, and she ends up with a countable asset and a transfer penalty stacked on top of it, which is the worst outcome available anywhere in this subject. So here is the sentence to carry into that appointment, word for word. Is a Medicaid-compliant annuity appropriate here? And if it is, will it be irrevocable, non-assignable, and actuarially sound, with the state named as remainder beneficiary? Ask it exactly like that. An elder law attorney will know immediately what you are asking, and anyone who does not is the wrong person to be buying this from. It also matters enormously whether there is a spouse still at home. Where there is, the income can be directed to them, and federal law specifically allows transfers for the sole benefit of a spouse. Where there is not, the income stream largely goes to the nursing home anyway, and the tool does much less than it looks like it does. Which brings us back to Joan and Wanda. Wanda and Ted sat down with an elder law attorney in the spring, while Ted was still well. $15,000 into an irrevocable funeral trust. $120,000 IRA moved into payout status, because their state is one of the dozen. The remaining $65,000 into a compliant annuity paying Ted, at home, month by month. On the day Wanda applied, her countable assets were under $2,000, with all $200,000 still hers. It had simply changed form. Joan's $200,000 was in a savings account the whole time. Every month it went down by $9,600. 20 months. Her husband watched the number fall and could not think of a single thing to do about it, because by the time anyone told him there was something to do, Joan was already in the facility and most of it was already spent. Joan did not make a mistake. Nobody handed her a bad document. She simply never learned that the form the money was in mattered more than the amount. Now the honest edges, because this only helps if it is the whole picture. None of this makes her rich. It protects what she has from being spent down to nothing. That is the whole ambition here. Timing is real. The funeral trust carries no penalty and can be done late. The other two are best done early, and anything that looks like giving assets away runs into the 5-year look-back. California is the exception at 30 months, with transfers made in 2024 and 2025 excluded entirely. These rules are set state by state, and they change. Every figure in this video is a 2026 federal or published number, and your mother's state may sit somewhere else. And I am not a lawyer. The first two she can raise at a kitchen table. The third one needs an elder law attorney who does Medicaid planning specifically, and 1 hour with that person costs a fraction of 1 month in a nursing home. And if she is already in a facility or already applied, please do not close this and decide it is finished. It is a shorter list, not an empty one. The funeral trust carries no penalty and works late. The retirement account question does not expire. What changes is that the options that need 5 years of runway are gone, and the ones that work in a week are the ones left. Ask anyway. The worst answer you get is no. So here is your one thing for tonight, and it is not a phone call to a lawyer. Ask your mother one question. Where is the money actually sitting? Not how much, where? A savings account, a CD, an IRA, a workplace pension. You are not planning anything tonight. You are finding out what form it is in, because that is the thing that decides what happens, and almost no family knows the answer off the top of their head. Write the list down. That list is what an elder law attorney needs in front of them, and it is the difference between a 1-hour appointment and a 3-hour one. Ted is still in the house. The annuity still pays him every month, and when Wanda's care is reviewed, there is nothing on the countable side to review. Joan's husband sold nothing and did nothing wrong, and he still watched $200,000 leave in 20 months, because by the time anybody explained the difference to him, there was no money left to move. What separated those two families came down to one question, asked about 18 months earlier than it usually gets asked. Your parents spent decades being the ones who handled things. This channel is how you hand some of that back. If this was useful, hit like and subscribe, because the next one is about what happens to the house when one parent goes into care and the other one is still living in it. I'll see you in the next one.